Afternoon, everyone. Welcome and thank you for attending this afternoon's program entitled The Revised Penal Code of the Philippines with Bar Questions and Suggested Answer Book 1, Book Launch and Lecture. Before we start, we would like to enjoin everyone to be in the presence of our dear Almighty Father for our opening prayer to be followed shortly by the singing of our national anthem.
Our Father which art in heaven, hallowed be thy name. Thy kingdom come, thy will be done in earth as it is in heaven. Give us this day our daily bread, and forgive us our debts as we forgive our debtors. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever. Amen.
Thank you, everyone. Before we proceed, we would like to remind all of you to keep your audio on mute and your video turned off. Again, good afternoon to all of you. I am Carla Bana from Rex Bookstore and I will be your host this afternoon. I hope everyone is safe, healthy, and in good spirits. Now, to officially open today's event, let us hear from Rex Bookstore's Chief External Affairs Officer, Ms. Danta Crimelda Aybuhain for the opening remarks and message from the publisher.
Good afternoon, our dear guests. I have the honor to open this afternoon's event and be part of yet another milestone for Rex. Rex Bookstore began in 1950 as a humble bookstore in Escarga, which is now Recto, engaged in the buying and selling of second-hand books. Now, 70 years later, we have grown into an organization providing learners across all ages with learning solutions that allow them to improve the lives and the lives of others. We publish books from pre-elementary, basic education, all the way to college, post-collegiate, and as you already know, quality law books written by our country's legal luminaries. This afternoon, we shall witness the launch of the very first edition of the Revised Penal Code of the Philippines Code of Provisions Book 1 with bar questions and suggested answers by Dean Jemmy Lito Festin. As prefaced, this book is, in a way, an innovative approach for a better understanding of criminal law. Rather than choosing to publish the naked, raw, codal provision of the Revised Penal Code, the author deemed it's wise to incorporate related bar questions with suggested answers to every particular provision of the law designed for easy recall and comprehension of otherwise intricate, complex, and sometimes confusing concepts and principles of criminal law. In addition, this book indicates how many times a particular provision of the RPC is asked in the bar examination, thereby helping law students study wisely by concentrating on the more important topics given their limited time of studying. Written in the midst of COVID-19 pandemic, this book is but a representation of resiliency, perseverance, and traits that are highly essential in the pursuit of the study of law. Allow me to formally introduce the great man behind this feat. An author of several best-selling law books, he obtained his Master of Laws from San Sebastian College, Recoletos, where he was conferred with recognition Beni Meritus. He is currently the Secretary General of the Philippine Association of Law Schools, or PALS. He is also the chairholder of the Chief Justice Panganiban Professional Chairs on Liberty and Prosperity Foundation on Liberty and Prosperity. A seasoned law professor, bar reviewer of an MCLE lecturer, he is currently the bar director of the PUP Bar Review Center and the dean of the Polytechnic University of the Philippines College of Law. And of course, a very, very, very good friend of ours. He's indeed truly a gem in the field of legal education. Friends, let us all welcome Dean Hemi Lito Festin.
Thank you very much. Good afternoon, Ms. Danda Buhain.
Good afternoon po.
Our Rex Bookstore team, our esteemed guests, friends, students, viewers, and to everyone. First of all, allow me to extend my felicitations to Rex Bookstore in supporting this humble handiwork by coming up with the idea of having a virtual book launching of this book I authored entitled The Revised Penal Code of the Philippines, Codal Provisions with Barred Questions and Suggested Answers book. Now, many complain about how difficult it is to understand criminal law. This statement I often hear mostly from freshman law students as well as bar reviewees. This assertion is actually true if one is to rely only on the naked raw or codal provisions of criminal law. And even if one is to read an annotated criminal law book, what is the guarantee that one can easily comprehend concepts like mala in se or mala prohibita, complex crime, the threefold rule, or the principle of nullum crimen, nullum poene sine lee, or the nomenclature of penalties like reclusion temporal, prison mayor, prison correctional, in relation to imposition of penalties. These concepts must not only be explained but illustrated. What better way for them to understand criminal law but to illustrate it by providing them with previous bar questions with suggested answers? And why not provide them with materials that will be a roadmap on how to review criminal law and how to present their answers? This book, in a way, answers that call. It is an innovative approach for a better understanding of criminal law. As mentioned by Ms. Danda, rather than choosing to publish the raw provisions of the revised penal code, it is deemed wise to incorporate bar questions with suggested answers to every particular provision of the law designed for easy recall and comprehension of otherwise an intricate or complex or sometimes confusing principles of criminal law. So immediately after reading a particular article of the revised penal code, students will be able to know how bar questions are framed based on that specific topic. In addition, this book indicates how many times a particular provision of the revised penal code is asked in the bar examinations. So by doing so, the students and bar examinees will be able to know which subject matter are commonly and not so commonly asked. This way, they will be able to study wisely by concentrating on the more important topics given their limited time of studying. Lastly, they will be able to learn how the answers are to be logically presented. As mentioned again by Ms. Danda, this book was actually written in the midst of the COVID pandemic during the so-called general community quarantine. But life must go on, and despite the uncertainties and challenges of the time, our journey towards the fulfillment of our vision must never stop. We are reminded of an event in the Holy Scripture where some men were sent by Moses to spy on the land promised by God to them. But when they returned, some of them were afraid to conquer the territory and even said, and I quote, "We are not able to go up against these people, for they are stronger than we are. The land that we have gone through as spies is a land that devours its inhabitants, and the people we saw in it are of great size, and to ourselves we seem like grasshoppers, and so we seem to them." But two men named Caleb and Joshua reported to Moses to go up at once and occupy the land that they are well able to overcome. They declared, "The land that we went through as spies is an exceedingly good land. If the Lord is pleased with us, he will bring us into this land and give it to us as a land flowing with milk and honey. Only do not rebel against the Lord and do not fear the people of the land, for they are not no more than bread for us. Their protection is removed from them, and the Lord with us. Do not fear them." To make the story short, Joshua and Caleb were able to enter and conquer the land because they believed they can. The others did not, because they did not believe that they are able to do it. The famous Austrian neurologist and psychiatrist Viktor Frankl, a Holocaust survivor, in his book Man's Search for Meaning, aptly said, "Everything can be taken from man but one thing, the loss of the human freedom to choose one's attitude in any given set of circumstances, to choose one's own way." He explained that between the stimulus and that of the response, there is a space. In that space is our power to choose our response. And in our response lies our growth and our freedom. So be encouraged. Now permit me to lecture on certain salient features of criminal law, book 1. Now, we start with the definition of what is criminal law. Criminal law is defined as criminal law it defines crime, traits of its nature, and it provides punishment. So not every law which seem like a penal law is not a criminal law, strictly speaking. In order for a law to be considered as criminal or penal law, it should define a crime, and traits of its nature, and provides punishment. What is the significance? If it is a criminal law, then it is entitled to what kind of interpretation? If there is doubt as to or ambiguity as to the interpretation of a penal law, it should be interpreted in favor of the accused and strictly against the government. So if it is a penal law, it is entitled to this interpretation in case of ambiguity or doubt. Now, if it is not a penal law, then it is not entitled to this interpretation unless that specific law provides otherwise. Okay, Congress is just a creation of our Constitution. So it cannot enact a law that runs counter to the provisions of our fundamental law, which is the Constitution. So we have constitutional limitations like due process. Okay, the accused must be given an opportunity to be heard, opportunity to air his side. Okay, we have the bill of attainder, we have the ex post facto law, in which the law must be prospectively applied. Of course, there is also a presumption of innocence. So all accused are presumed to be innocent unless proven otherwise. So this is the presumption of innocence. Of course, this is just a presumption which can be rebutted. But what quantum of evidence to rebut that presumption of innocence? By proof beyond reasonable doubt. So if the prosecution can adduce evidence, okay, which is the quantum of evidence of proof is proof beyond reasonable doubt, it can destroy already the presumption of innocence. Okay, but if they are unable to adduce a quantum of evidence by proof beyond reasonable doubt, then that presumption stands. Of course, there is a right to counsel, and there is a right to be informed of the nature of the cause of accusation against him. Okay, this is done during arraignment. Now we go to characteristics of criminal law. Okay, let me share my whiteboard screen. Okay, characteristics of criminal law. So we have the general. The first one is the general. First, there is also the territorial as well as the prospectivity. Let's discuss general. Now, most of the students interchange or get confused with the general characteristic with that of the territorial. General refers to persons. Okay, so you start with all persons. When you talk about the territorial rule, it speaks about the place. In general, it speaks about persons. So all persons, okay, who live or sojourn in the Philippines are subject to our own criminal law. Though they cannot raise as a matter of defense their national law, okay, because they live or even just visiting the Philippines are subject to the Philippine criminal court proceedings. So they cannot just say that in the state that they belong, it is lawful to possess marijuana. But if you're in the Philippines, it is not. So you have to abide by our rules. Now, this rule is not an absolute rule. There are exceptions. Number one exception is laws of preferential application. Preferential application. What does it mean? The law gives preference to a particular class of person, such that if that person belongs to that class of persons, then he is not covered by our criminal law. So under public international law, we've got the sovereigns, okay, the heads of the state, the ambassadors, ministers plenipotentiary, ministers residents, and charge the affairs. Okay, they are not covered even if they are in the Philippines. Now, what about domestic servants? Under the Public Act 75, domestic servants of an accredited ambassadors in the performance of their duties and functions, they are now also not covered. Let's go to territoriality or the territorial rule. Okay, it talks about, as I've said, place. So all crimes, the general rule, okay, all crimes committed within, okay, within the Philippine territory is subject to our Philippine criminal law. So all crimes, therefore, okay, which are outside the Philippines, then Philippine courts have no jurisdiction to try the case. So it's very clear, for as long as the crimes are committed within the Philippine territory, Philippine courts can exercise criminal jurisdiction over the act. But all crimes committed outside the Philippine territory, Philippine courts have no jurisdiction to try the case. Is that an absolute rule? No, there are exceptions. Exceptions meaning to say that although the crime is committed outside the Philippine territory, yet Philippine courts still have jurisdiction to try the case. Okay? We call it extraterritorial application 2. So they are enumerated under Article 2 of the Revised Penal Code. Number 1, it should commit an offense while on a Philippine ship or airship. So how do you know that it is a Philippine ship or airship? It does not depend upon the nationality of the owner of the vessel. It does not depend upon also the nationality of the parties involved, the complainant as well as the victim. You consider it a Philippine ship or airship if it is registered in the Philippines, particularly with the Bureau of Customs. The second is should forge or counterfeit any coin or currency notes or obligations or securities issued by the Philippine government. So it refers to a forger. Even if the crime is committed, say for example, in Singapore, within the territory of another state, and even if it is committed, if the act of forging is committed also in Singapore, but if it concerns our coin and currency notes or obligations and securities, they can be tried in the Philippines for such act. The third is it should be liable for the introduction of the obligations and securities mentioned on the previous section. This refers to a smuggler. If they smuggle the obligation and securities issued by the Philippine government, okay, if they smuggle it, even if they exchange hands in the high seas, together with the Filipino, to meet the Filipino counterpart smuggler, they can also be liable. Fourth is a public officer who commits a crime, okay, in the discharge or related to his functions or duties. Now, you have to remember that it does not follow that just because a crime is committed by a public officer outside the Philippines, ipso facto, okay, automatically we have jurisdiction to try the case. No, it must have some relevance in the performance of his or her duties and responsibilities. So if the public officer who commits a crime, okay, of malversation is a disbursing officer, then that is a related to his duties and responsibilities or function, and he can be tried, okay, in the Philippines, even though the crime committed is outside the Philippines. Number 5, should commit against a crime against national security and the law of nations. Now, this gets confusing to others. So assuming that this is the Philippines, okay, this is the territory of the Philippines, and one is A and B are in Hong Kong. A and B, they purchase arms, okay, to support. Assuming that there is rebellion in the Philippines, okay, there's some group of men who are taking arms against the government, okay, and intending to overthrow the government, and they are the ones supporting the same. Okay, when they went back to the Philippines, they were prosecuted. Okay, now they claim, of course, that since the crime is committed outside the Philippine territory, then uh, we have no jurisdiction to try the case. Prosecution contends that they should be tried in the Philippines. So what is the answer? Okay, would their acts be deemed as a crime against national security or the law of nations? Okay, so they were charged by the prosecution for rebellion. Can they be charged of rebellion? Would the rebellion prosper? Is it a law against national security? It is not. Rebellion is a crime against public order. Ergo, Philippine courts have no jurisdiction to try the case. Okay, the exception will not apply. The general rule will apply that crimes committed outside the Philippine territory, okay, Philippine courts have no jurisdiction to try the case. Okay, remember that. Crimes against national security would be treason, misprision of treason, espionage, violation of neutrality, or piracy would be a law against law of nations or humanity. So the thing is that you've got to memorize what are those crimes against national security and the law of nations. So, okay. Now we go to felonies, Article 3. Felony. Acts or omissions punishable by the revised penal code are called felonies. So crimes committed, okay, in violation of a special penal law cannot be considered as a felony. It is only an offense or a crime in general. So you've got to determine that we just go back on the difference between crimes punished under the revised penal code from that of special penal law. Aside from crimes committed are called as felonies in the RPC. Crimes committed under the RPC are called to be mala in se. When you talk about mala in se, it is evil in its nature. SPL, like murder, okay, homicide, robbery. SPL, it is mala prohibita. Not necessarily evil, but it is a crime because there is a law that prohibits the performance of a particular act and the offender voluntarily, okay, violates the same. Like illegal possession of firearms, it is not mala in se, it is not evil in its nature. But since in our jurisdiction, okay, possession of firearms is illegal as a general rule, and unless there's a license, and if someone violates the same, it is deemed as mala prohibita. Now, since mala in se, since RPs, but not, remember, not all crimes against RPC, okay, punishable under the RPC is they are deemed as mala in se. There's one also which is deemed as mala prohibita, although it's an RPC. It's technical malversation. Technical malversation when there is a law, okay, that allocates a public fund for a particular purpose, and that public fund, okay, was used for another public purpose other than to which the law or the ordinance intended it to be used. So is good faith a proper defense in technical malversation? No, because it's mala prohibita. Okay, kasi in mala in se, good faith is a proper defense. So if a person is charged of murder, you can raise good faith. It is only an act of self-preservation, self-defense. Okay, what about in SPL? Mala prohibita, but there are also exceptions. One would be plunder. Plunder is punished under special penal law. but it is deemed as bala in se. So therefore, good faith is a proper defense. Okay, so but general rule, SPL, malabruibita is good faith is not a defense. What else? The stages of execution, which are the consummated, frustrated, and attempted. They are determined in RPC, crimes punished under the RPC, in order to arrive at the proper penalty to be imposed. In SPL, no need, because the crime is deemed to be in a consummated stage. And there is a specific penalty provided for by special penal law. Although there are some SPL that uses the stages of execution, but generally, okay, it has those stages of execution because it is deemed, the act is deemed to be committed on a consummated stage. Persons criminally liable. Who are they? The principals, accomplices, accessories. We determine that in crimes punished under the RPC. Why? To arrive at the proper imposition of the penalty. In SPL, okay, the offender is deemed to be a principal, no accessories, no accomplices. Generally, although there are some crimes which adopt this person's criminally liable, like in the anti-terrorism law, okay, there are that persons liable expressly therein are principals, accomplices, and accessories. So they, how do we determine it? Because in consummated, frustrated, and attempted, and principal, accomplice, accessories, in Book 2, crimes committed under Book 2, specific crimes, are deemed imposed upon a principal on a consummated stage. But if it is frustrated stage and not consummated, it is 1 degree lower than that imposed upon a principal on a consummated stage. If it is in attempted, it's 2 degrees lower than that imposed upon a principal on a consummated stage. Now, if it is committed by an accomplice, it's 1 degree lower than that imposed again upon a principal on a consummated stage. Accessories, 2 degrees lower than that imposed upon a principal on a consummated stage. So remember that. That's why it's significant in RPC. We determine that because it's entitled to a lessening of 1 or 2 degrees lower. And we talk about degrees, we talk about the nomenclature of penalties under the revised penal code, like reclusion perpetua, reclusion temporal, prison mayor, prison correccional, arresto mayor, arresto menor. Now, what else? The appreciation of mitigating and aggravating circumstances. We appreciate that in order, again, to arrive at the proper penalty to be imposed. So ordinary mitigating as against generic aggravating, we offset each other to determine the proper period to be imposed, whether it's minimum, medium, or maximum period. Okay, so it refers to rule of offsetting in a divisible penalty. But in special penal laws, wala silang ganon. Okay? We do not appreciate the presence of mitigating and aggravating circumstances, okay, in order to arrive at the proper penalty to be imposed. Also, last, the nomenclature of penalties. As I mentioned a while ago, you've got reclusion perpetua down to arresto menor. But in SPL, okay, they give specific penalty. It does not use the nomenclature of penalties anymore of the RPC. So there's a one-bar question. Differentiate the crimes punished under the RPC, reclusion perpetua from life imprisonment. Reclusion perpetua is a penalty imposed under the revised penal code. It has a duration of 20 years, 1 day to 40 years. Life imprisonment, okay, is imposed where the crime committed is punished under a special penal law. And it has no duration, just like that of reclusion perpetua. But last, okay, there are instances where the nomenclature of penalties are adopted or borrowed under the special penal laws. So even if it's an SPL, it uses the nomenclature of penalties under the revised penal code. That is why when we compute the proper penalty to be imposed under the indeterminate sentence law, the formula, the rules that we're going to use would that be of the RPC and not that of the special penal law. Okay, so let's go back to felonies. Felonies, they are divided into two. You've got dolo and culpa. Elements of dolo, you got freedom, you have intelligence, and you've got criminal intent. Okay, synonymous also to evil motive, acting in bad faith or malice. It connotes evil intent, also bad faith and malice. In culpa, the elements are freedom, intelligence, imprudence, negligence, lack of foresight, and lack of skill. Imprudence connotes what? Deficiency of action. Negligence connotes deficiency of perception. Now, if you are the prosecutor, you've got to prove the elements of dolo. Like if it's murder, so you've got there's freedom, prove there's freedom, there's intelligence, there's freedom intent. Now, if you are the counsel for the accused, okay, remove any of those elements, then your client will be acquitted. So how do you negate freedom? Okay, how do you negate freedom? By proving what? Irresistible force. Irresistible force is an exempting circumstance under Article 12 of the revised penal code. Intelligence. Okay, you prove that your client is 15 years old or under. Total exemption from criminal liability. Now, if your client is 16 years old but below 18, you prove that he is acting without discernment, that he does not know right from wrong. Okay, so how do you negate intent if you are the defense counsel? Okay, now if criminal intent connotes bad faith, what's the opposite of bad faith? Good faith. Good faith negates criminal intent. Okay. Now, culpa, they have the same element except the third one. Now, the question is, would good faith be a proper defense to culpa? The answer is no. A person may be acting in good faith, but he can still be negligent. He can still be negligent because he may be overspeeding, in which case he is criminally liable. Okay, the case of Achong is that in dolo, there must be mens rea and actus rea. Criminal mind and criminal act. Those two must go hand in hand. So in the case of Achong, there is no mens rea because he was only performing a lawful act. Okay? So yung US versus Achong, it raises the noble defense of mistake of fact, which is not the same as that of mistaken identity. Mistake of fact. Okay, somebody was not, Achong was sleeping. Okay, he had a roommate, and okay, crime was prevalent in their neighborhood at that time. So somebody was banging on the door, and he was asking, "Who are you?" But the question left unanswered. Eventually, that person was able to get in, and Achong, thinking that his life is in danger, stabbed and killed this person. It turned out that it was his roommate playing a joke on him. Okay, he raised this mistake of fact as a matter of defense, and he was acquitted because of that. And these are the requisites. Okay, the act would have been lawful. His act of stabbing, okay, his roommate would have been lawful had the facts been as the accused believe it to be. If that person is really an intruder, then his act of stabbing him would be lawful. Next, intent is also lawful. He is only what? Defending himself. And lastly, there is no carelessness or without carelessness on his part or negligence. He verified the identity of the person by asking, "Who are you?" But the question was left unanswered. So if these three are present, there is no criminal liability because there is no criminal. Let's go to Article 4. How criminal liability is incurred. Criminal liability is incurred in two ways. Number one, by committing a felony. Although the wrongful act done be different from that which he intended. So there is a wrongful act done which was committed, and however, the resulting injury is different from that of which he intended. Now, is this felony applicable also to all types of felony like dolo and culpa? No, it is not applicable to not NA to culpa. Why? You can sense it already because of the provision of the law, which states there that although the wrongful act done be different from that which is intended. So there is intentional felony. So this is applicable only to intentional felony. So not applicable to negligent act. Not, not also applicable if the crime committed is an SPL or punished under special penal laws. Not applicable also if one is performing a lawful act. Okay? So one who is committing an intentional felony is liable for the direct, natural, and logical consequences of his unlawful act. Liable also for the resulting injury. Okay, the resulting injury is the direct, natural, and logical consequences of his unlawful intentional act. Then Article 4, Paragraph 1 finds application. Although the resulting injury again will be different from that which he intended. So Article 4, Paragraph 1 speaks about proximate cause also. And proximate cause is based on the principle that he who is the cause of the cause is the cause of the evil cause. So say, for example, that X is a passenger of this jeepney, and robber 1 and robber 2 went inside the passenger jeepney and declared a holdup. So they were amassing all these personal properties from some of the passengers. When X, okay, was fearful for the actuations of R1 and R2, So he jumped out of the passenger jeep. Unfortunately, her head hit the pavement of the street and she died. The prosecution filed a case against R1 and R2, and the prosecution also states that they're also liable for the death of X. Now, R1 and R2 contends that they are not liable for her death because they did not kill her. It was her voluntary act. That's why she went out of the passenger jeep. Okay, and the question is the argument raised by R1 and R2 credible or lawful or correct? No, because of the principle of proximate cause. Because of Article 4, Paragraph 1, in saying that a felony is committed although the wrongful act done be different from that which she intended. Okay, so were it not for the actuations of R1 and R2 in declaring a hold up and in obtaining all those personal properties of the other passengers, X would not have jumped out of the passenger jeep. She only jumped because she was fearful for her life. Okay. Of course, it also applies the error in personae, which is mistake of in identity. Notice that in all these instances, mistake in the blow, mistake in identity, praeter intentionem, there is criminal intent. So if A intended to kill B and he planned to kill B, waited for B to walk in the street at night because he knows at the time that after work he will pass by the street, stop this person. It turned out that it was another person, C. Okay, is A liable for the death of C? Sabi niya hindi. It's because that is only my negligent act. I have no intention to kill C. Would the argument be tenable? No, because at the onset, when he waited for B, there is intent to kill already. Intentional felony. Second is mistake in the blow. Or aberratio ictus. This is characterized class. You have to remember that ang magic words dyan would be lack of precision. Lack of precision. So if A intended to kill B, because of lack of precision, the bullet ricocheted and hit another person. So how many people are present at the scene of the crime in mistake in the blow? There are 3. A, B, and C. What about in error impersonate? 2 only, A and C. But A believed that C, when he committed the crime, is B, and actually another person. So remember that. So mistake in the blow may even result to complex crime under Article 48 of the Revised Penal Code, assuming that the single act produces 2 or more grave or less grave felonies. Assuming that those 2 are present, then it will lead into complex crime. The third one is the injury is greater than the intent. The resulting injury is greater than the intent or praeter intention. So if A only intended to slap B because the slap was so strong, B fell down. Again, he said hitting the pavement of the street and B died. The intent to slap, the injury sustained by B, which is death, is greater than that intent of A, which is only to slap the face of B. This is a mitigating circumstance of under Article 13, lack of intent to commit so grave or wrong. Let's go to the second. We still have 10 minutes before we go into bar questions. Let's go to impossible crime. Paragraph 2 speaks about impossible crime. Paragraph 2 of Article 4 speaks that provides that by performing an act which would be which will be a crime against persons or property, were it not for its inherent impossibility or on account of employment of inadequate and ineffectual means. Okay? So the crime is not committed. Okay, there are also other elements which are not present in the caudal provision. The act must not be punished under other provision of the RPC. If that act is already punished under other provision of the RPC, then there is no impossible crime anymore. And of course, there is evil intent. Okay, let's discuss this one by one. Impossible crime, okay, is only limited to crimes against persons and property. So the moral lesson there is to memorize what are those crimes against persons and property. So murder, homicide, physical injuries, among others. Property would be robbery, theft, estafa, malicious escape, among others. What about kidnapping? They kidnapped the wrong person. Is that a crime against person? No. It is a crime classified as a crime against personal liberty. So it's not applicable. Inherent impossibility. It is not susceptible of being consummated because it is inherently impossible. So there is legal, there is physical impossibility. There is also legal impossibility. Physical impossibility. Can you kill a person who's already dead? No. Why? Because it's already dead. So A intended to kill B, but unknown to A, B already suffered heart attack an hour earlier. So A all along thought that B was only sleeping. Stabbed B. A, is there impossible crime? Yes. Because A believed at that time that B was alive, but in truth and in fact, he's already dead. If he knew at the time, and this is the trick in the bar, if he knew at the time that he was already dead and still stabbed him, then impossible crime is not applicable. Employment of inadequate or ineffectual means. So A intended to kill B, believing, and he put a poison in the cup to be given to B, believing that this volume is enough to kill the other person. But unknown to him, the volume must be this much. Okay? So if he knew at that time that the volume is not adequate to kill B, then forget about the application of impossible crime. Employment of ineffectual means. A intended to, if one intended to kill B by using a poison, and he put a substance therein, believing that it was poison, wherein truth and in fact, and unknown to him, okay, it's only sugar. So employment of ineffectual means. Of course, the act should not be punished under other provision of the RPC. So if A intended to kill B by burning the house of B, but unknown to A, B already left the house a week earlier, he went to Manila, assuming this happened in the province, and A burned the house of B, believing that B was present, and B did not die because he was in Manila. That's impossible. There is no impossible crime. Why? Because that act is punished under other provision of the revised penal code, which is the crime of arson. Now, in impossible crime, objectively, there's no crime, but subjectively, there is crime committed to address also the criminal propensity of uh, the perpetrator. So there's a specific penalty provided for by the RPC in impossible crime. Okay, so the last topic before we go into the codal provision at the bar examination, we go into stages of execution. But prior to that, okay, the development of a crime, internal acts, and external acts. External acts, we've got preparatory acts and acts of execution. Question, are internal acts punishable? No. You can think of any crime for as long as it stays in your mind and there's no overt act. So, no criminal liability. And it's absolute. Okay, no exception. What about external acts? We go to preparatory acts. Are preparatory acts punishable? Okay, as a rule, preparatory acts are not punishable unless there is a law that already punishes that particular act. If that act is not punished under other provision of the RPC, it's not punishable. So if one intends to kill another person by using insecticide, siguro will place that in the food, then there is no crime committed because buying insecticide is not punishable. But if one intends to rob another person, and he was to do that, he was in possession of picklocks, then he will be, that is punishable already. Legal possession of picklocks. But not liable for attempted robbery because this is just a preparatory act. Okay, when you talk about acts of execution, you're talking about consummated, frustrated, as well as attempted stages of execution, in which there is criminal liability. So attempted is that he commences, look at your codal provision, he commences the commission of a felony directly by overt act. And he does not perform all acts of execution which will produce the felony. In other words, the crime is not consummated. So why is it not consummated? The reason is that for reasons or accidents other than his spontaneous desistance. Spontaneous desistance is material in the attempted state. If there's spontaneous desistance, there is no attempted felony. Okay? And these are the requisites. So if A intended to kill B, and he pointed his gun on the person of B, but he had a sudden change of heart, he desisted and walked away, then he's not liable for attempted homicide or murder as the case may be. Why? Because there is spontaneous desistance. Spontaneous desistance is appreciated because it is a form of a reward given by the state for a person who, at the brink of committing a crime, heed the call of his conscience and return to the path of righteousness. Okay? So not liable for attempted, but will he be liable for any act? Yes. He will be liable only for grave threat because the act of pointing a gun on the person of B already constitutes the crime of attempt of grave threat. Now, if A, second scenario, if A pointed the gun on the person of B, and he shot B actually, but only B suffered slight physical injuries. Okay, the one hit is only his finger, and it is not a mortal wound. Would you say that it is attempted? Yes, it is attempted. Okay, so let's go into the elements of the crime. Did he perform all acts of did he commence the commission of a felony by directly by overt act? Yes, he pointed his gun on the person of B. Okay, did he or did he not perform all acts of execution? He actually shot B, but it was not a mortal wound. If A lives, then B would survive. So that means there's still another shot, okay, needed to kill B. So in essence, it means that he was not able to perform all acts of execution. If the wound is not a mortal wound, then it could be attempted. Okay, why? If the wound is mortal, it may be frustrated, because in frustrated, the elements is that he already performed, okay, all acts of execution which would produce the felony, but it was not produced. Okay, not produced. Why? Is it other than spontaneous resistance? No. Okay, independent of the will of the perpetrator, or independent of the will of the accused. Meaning the crime was not consummated and the offender has nothing to do with it. So if if uh, A shot B and B suffered a mortal wound, okay, siguro what was hit was his heart, his intestine, his kidney, and A walked away believing that there's nothing more to be done because he was already dying. But when A left, okay, C saw what happened to B, and C is was a good Samaritan and brought B to the hospital. And because of timely medical attention, okay, B survived. So did he perform all acts of execution which would produce the felony on the person of B? Yes, because it is a mortal wound. Okay, did the B die? No, the felony. So it shows you that you have to master this provision of the law. So what is good in this in my book is that it has indication of how many times this was asked in the bar exam. This one. Okay. So let's look on the next question. Okay. Ando, an Indonesian national who just visited the Philippines, purchased a ticket for passenger vessel bound for Hong Kong. Say it's the person here is Ando, Indonesian siya. Okay. Visited the Philippines, purchased a ticket bound for Hong Kong. So ticket, so he's now in the vessel bound for Hong Kong. And while on board the vessel, he saw his mortal enemy, Jason, also an Indonesian national, seated at the back portion of the cabin and who was busy reading a newspaper. So Ando stealthily approached Jason, and when he was near him, Ando stabbed and killed. These are material facts. Ando stabbed and killed Jason So he killed Jason. That's the crime that he committed. The vessel is registered in Malaysia. So vessel is in Malaysia. Registered in Malaysia. The killing happened just a few moments, and this is the trick. The killing happened just a few moments after the vessel left the port of Manila. It just left moments after the vessel left Port of Manila. So although the vessel is registered in Malaysia, the venue or where the crime is committed is still within the Philippine territory. So subsequently, operatives from the PNP Maritime Command arrested Ando, presented the killing of Jason. Also, Ando contended that he did not incur criminal liability because, number one, okay, he was asserting that he's an Indonesian and that the vessel is registered in Malaysia. So discuss the merits of Ando's contention. So got to remember, class, always the question that is asked, discuss the merits of Ando's contention. So you have to address the first and the second contention of Ando. So what do you remember in this case? The territoriality rule. That if the crime is committed within the Philippine territory, then we have jurisdiction to try the case, except when the vessel is outside. Now, where is the vessel? Is it outside or within the territory of the Philippines? It is within the territory of the Philippines. So the exception would not set in. So it has no bearing whether the vessel is registered in Malaysia, simply because the venue of the crime is within the Philippine territory. Okay, does it matter if he's an Indonesian? No. If the national law bears no significance in criminal cases because it is if the crime happens within the Philippine territory. Okay. So let's look at the suggested answer. Now, class, whenever you have whenever you answer, you should be guided by reply, legal basis, application, and conclusion. As much as possible, kung if there's you can conclude, or otherwise at least the legal basis, reply, or the response, or your legal basis as well as the application. So sabi, the question asked for discuss the merit of Ando's contention. So okay, you have to face it squarely. So you need to respond or to reply. Ando's contentions have no merits. Number two, I said legal basis. Legal basis. You discussed the territoriality rule. Okay, provides that crimes committed within the Philippine territory are subject to its criminal jurisdiction. Okay, the application. In this case, the crime was committed inside the Philippine territory. Then our criminal courts have jurisdiction to try to hear the case. Continuation. It is of no moment that the victims are foreigners, since as a rule their national law is not applicable in criminal cases. So that's his contention, diba? That is Indonesia. Okay, number two, whether it's a Malaysian registered vessel has to also bearing because it happened a few moments after the vessel left the port of Manila, still implying that it is within the Philippine territory. So consequently, Ando may be prosecuted in Manila, in the Philippines. Okay. So let's have an example. Article 3, what does it suggest? Tingnan nyo Article 3. Okay, Article 3. How many times they were asked in the bar? What does it tell you? It tells you that you have to study and master Article 3. Okay? So these are the codal provisions. And look at the bar question. This is basic question. Okay? You have to, this explains why you need to memorize at least articles 1 to 20 in book 1. How are felonies committed? This is your answer, the article. Felonies are committed not only by deceit, and it's also dolo. So there's no excuse why this answer you cannot, this question you cannot answer. Okay, next. We discuss Article 4. Look at Article 4. How many times was it asked in the bar exam? Look, last year, the other year, then 11, 12, 13, 14, 15. Look at that. Okay, 3, 4, 5, 6, 7, 8, 9. So you have better put a star when it comes to Article 4. That explains why I lecture so much on Article 4. Look, this fine distinguish the following terms: aberratio equals error, personae, greater intention. I discussed that already a while ago, and it's only basic. Perhaps last question. Okay, let's look. On his way home, from the office, ZZ rode a jeepney. Subsequently, X boarded the same jeepney. Upon reaching a secluded spot in Quezon City, X pulled out a grenade from his bag and announced a holdup. He told ZZ to surrender his watch, wallet, and cell phone. And fearful for his life, ZZ jumped out of the window, but as he fell, his head hit the pavement, causing his instant death. Is ZZ liable for ZZ's death? Explained fully. So this is similar to the illustration that I gave you a while ago. So how will you answer this one? Okay. Okay, I told you number 1 is reply. Okay, this is just my advice. No? This is my advice. Okay, is XX liable for ZZ's death? Respond. XX is criminally liable for the death of ZZ. Z and Z. If you want, you can put this sentence after the first sentence. Or you can say, yes, XX is criminally liable for the death of CC because Article 4, Paragraph 1 states that criminal liability shall be incurred although by a person committing a felony, although the wrongful act done be different from that which he intended. Okay? You can also add the principle of proximate cause. Proximate cause. Article 4, Paragraph 1 speaks about proximate cause. Okay, let's go there. So we have the legal basis already. Now we go to application. So in the facts given, in the given case, okay, XX committed a felonious act when he pulled out a grenade and declared a holdup. Okay, created an immediate sense of danger in the mind of CC. You can also bring this down to application 2. You can state that the actuations of the accused, okay, are the proximate cause of the death of the victim in this case. Their actuations would be deemed as the proximate cause of the death of the victim in this case. So you can trace already the conclusion. Consequently, the death of CC caused by fear from XX acts makes the latter criminally liable. Okay, if you still have time, you make a conclusion. Okay, by only rewarding your reply. But the most important here is the reply, the legal basis, as well as the application. Okay, so I think I don't have much time. Thank you very much, Rex Bookstore, again for the opportunity that you've given me, and I wish everyone good luck and keep safe, and hoping that all of you will become future lawyers. Thank you very much.
Thank you for that very presentation, Din Festin.
Thank
We
you.
are very honored to receive such expert guidance, especially at a time when the study and practice of law have become more challenging. Tell us more about how the book can be of great help. We will now listen to expert testimonials. We begin now with no other than Dean Tony Lavina of Ateneo Graduate School.
To encourage and endorse to everyone, and that is to law students, first year law students taking up criminal law, fourth year law students taking criminal law review, those who have finished already their law school and now are going to take the bar in 2021 and need to review criminal law properly. And I would say even those who are practitioners who need something solid about criminal law. I would endorse this book, this latest book by Dean Jeremy Festin of the Polytechnic University of the Philippines College of Law. Penal Code of the Philippines, Codal provisions. It breaks down the Codal provisions in a very clear, comprehensive, but also concise way. It includes information about how the bar exams have approached these particular articles, number of questions that have been asked about this article. And those questions are actually replicated with suggested answers provided by Dean Festin. I would have wanted to have this resource when I was taking up my bar exams many years ago, or when I was teaching criminal law in UP, in the University of the Philippines, in my first years as a law professor. Because in the end, the bar exam in particular is really about the mastery of codal provisions. I mean, cases are good, but memorizing and understanding and linking provisions to each other is really important. And having ready-made resource for bar questions in criminal law and arrange according also to the articles and indicating how much they've been, how many times they've been asked, and having the suggested answers to also be very good resource for all law students, all bar takers, and yes, all practitioners. Thank you, Rex Bookstore, for publishing this important book, an important resource for all of us. Maraming salamat.
And now, to tell us more about how the book came about, the product of expert study and research, let us all hear from the number one bar top notcher last 2000 bar examinations, Attorney Judy Lardizabal.
Congratulations, Dean Gemelito Festin, for your new book, Revised Penal Code with Bar Questions and Suggested Answers, Book 1. Your book has been written with the interests of all aspiring lawyers in mind. It is reader-friendly, it is presented based on codal provisions, and supported by past bar examinations and suggested answers. Your book is a must-have for all law students and bar reviewees. Not only will it help them understand the provisions of Book 1 better, it will also give them an idea of the provisions which are considered to be bar exam favorites based on the frequency of their inclusions in the past bar examinations. I highly recommend your book to all of law students and those who are reviewing for the bar. Again, Dean, congratulations for another fascinating work. More power and God bless you.
And now, for the next book testimonial, let us all hear it from Miss Mary Abigail B. Modales, Juris Doctor Student.
Good afternoon, everyone. Thank you for attending this virtual book launch. I am Mary Abigail Modales, currently a first-year student at the PUP College of Law, and I've been given this beautiful opportunity to represent the student sector and give a short review on Dean Festin's new book, The Revised Penal Code, complete with codal provisions, bar questions, and suggested answers. So I'd like to start this short review by sharing or giving you a glimpse of how law school has been for me these past few weeks. And I believe that my classmates as well as other law students would agree with me when I say that the first weeks of law school is pure adjustment. In a way that even though it's already a given fact that law school is an equalizer and that it really doesn't matter in the long run, whatever course or undergraduate degree you took. However, being a graduate of BA Broadcast Communication, which isn't really a course that you would take if you're really intending to take up law, there are a lot of terms, a lot of theories, bits and parts of the law that is taking me some time to fully grasp and fully understand. And this new book by Dean Festin is helping me in two ways. The first way is that it's providing me with my immediate need. And as a first-year law school student, my immediate need is to be able to read the codal provisions in its raw text. And this book provides me that. And aside from being able to read the codal provisions of the RPC in its raw text, I'm also given the opportunity to understand it faster and better because it's placed side by side with bar questions and suggested answers. So what I do is every time we're assigned with readings, and on that case, a specific codal provision from the RPC is applied, I go or read this new book by Dean Festin, see how the codal provision is applied in a bar question and how it is answered, and it provides me with a better explanation and gives me better understanding of how that codal provision is applied. And aside from my immediate need, this new book also provides me with better leverage for bar preparation. And I know as a first-year student, some of you might be thinking that it's too early to talk about bar preparation. However, in the College of Law of PUP, we're taught by our professors that every single hour of our classes, be it synchronous or asynchronous, it should be gearing us towards preparation on preparing for the bar. And this book gives us the opportunity to see as early as now how bar questions are being formulated or being placed, and at the same time it gives us the opportunity to see how these bar questions should be answered. So it's an immediate application of what we're being taught in our classes. So if you're like me, where you're in the adjustment period of knowing how codal provisions of the RPC should be applied, and if you're taking some time in understanding codal provisions, then you should go ahead and buy yourself a copy of this new book by Dean Festin. But if you're a fourth year student or a third year student preparing for the bar or taking the exam, then there are more reasons for you to buy this new book. Dean Festin, thank you so much for giving the students this kind of help, this kind of reference. Thank you for thinking of us when writing this book, and thank you so much for inspiring us to gear towards becoming excellent students. Once again, thank you everyone for coming to this book launch. Dean Festin, congratulations. We thank you and we're very happy for you. God bless you, and we declare success on this book.
And last but certainly not the least, he is a law professor of Master in Human Rights and Democratization. Let's all hear it from Attorney James Gregory A. Villasis.
Gregory Villasis. I am a lawyer and a law lecturer. I would like to share some of my thoughts about the latest book of Dean Jem Festin on the Book 1 of the Revised Penal Code. Dean Festin is an authority in criminal law, and his career as a dean, practicing lawyer, and an academician spanned for decades. This training and expertise are encapsulated on his latest book. In this book, Dean Festin discusses the principles of criminal law with a foresight to the bar exams. His manner of discussing these topics is most necessary for law students as they prepare for the bar examinations. And not only that, the book also gives a useful guide to law professors and reviewers as this provides them the favorite areas in the bar examinations. The book is straightforward, it is result oriented, and reader friendly. I congratulate and thank Dean Jim Festin for coming up with this book.
Thank you very much, Dean Luna, Attorney Lardy Zabal, Ms. Modales, and Attorney Villasis. We from REC share the same level of gratitude for your trust over the years, as well as for your unrelenting service to the legal profession and to our country as a whole. We are very honored to be part of this milestone as we continue to work together to champion legal education. And now, to officially close today's event, let us hear from Rex Bookstore's General Manager for CLV Law, Mr. Reginald Soriano.
Pleasant good evening to everybody. My name is Reggie Soriano. I represent the CLV team, which helps manage the law segment of our market. And first and foremost, good evening, Miss Danda. Good evening, Dean Jemmy Festin, and to our distinguished panelists. It's an honor and a privilege to be here to be able to somehow put a point that we would like to always emphasize here in Rex. Rex believes in enabling each and every learner for us to empower them, to enable them to achieve their dreams. The book that we are currently launching, and we are so humbled for the partnership, Dean Festin, that you have given us this honor and privilege to be part of this, uh, providing this learning solution. The book of the Revised Penal Code of the Philippines with bar questions and suggested answers is truly a great material that has been crafted with the learner in mind in how to support them. Maybe the best anecdote I can just share with everybody was that I remember my father-in-law when he was still here with us, and during those times that I have got to speak with him and have these conversations with him, I remember that one of his dreams was that he was never able to take and pass the bar. He took it three times and unfortunately was not able to do so. Um, this is one of those things that we can see as a challenge for our bar practitioner or bar pass for our law passers. We want to be able to give them the right tools, the right uh, tools that will empower them and ensure that their journey, not just from passing their classes or law degrees, but more importantly, realizing that dream and becoming full-fledged lawyers and therefore passing the bar. So with that, we would like to again thank you, Dean Festin, for being part of this journey of Rex learning solutions and providing for our lifelong learners. We are so humbled again and thankful for this partnership. God bless everyone. Maraming salamat po.
Thank you very much, Mr. Reginald Soriano. That's up. That sums up this afternoon's learning program. Indeed, it was a very productive learning afternoon with all our experts, especially Dean Christine. In behalf of Rex, I thank all of you for learning with us. Thank you, and let's all stay safe and healthy.